At Zambrano Law, we believe that the best DUI is no DUI. Whether we can assist you in court or offer you free advice, it is our pleasure. Getting a DUI can be very traumatic for most people. One of the most common statements we get when evaluating any Los Angeles or Orange County DUI case is, "I wasn't read my rights." People express great concern over this and wonder if this is, in fact, a violation of their rights and one that will result in dismissal of their DUI case. So, are the police required to read you your rights before questioning you in DUI investigations? The short answer, no. The rights we are referring to here are known as your Miranda rights, which state as follows. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you free of charge prior to questioning. Miranda warnings are designed to protect you from inherently coercive police situations and are required to be read before questioning anyone during a custodial interrogation. For purposes of Miranda warnings, custodial means any situation in which a person is not free to leave or otherwise feels free to terminate the encounter. Interrogation refers to direct questioning by the police designed to elicit an incriminating response. So there you are, standing on the side of the road next to your car, surrounded by police officers in the middle of a DUI investigation. You are being asked all sorts of questions about what you had to drink, how much you drank, and when you drank. Did you feel free to leave? Do you feel as though you are free to terminate the encounter? Do you feel that answering these questions may incriminate you? Yes, yes, and yes. So why aren't you read your Miranda rights before the police question you during your DUI investigation? Unfortunately, the courts have held that these questions asked of DUI suspects are asked before the driver is in custody for purposes of Miranda warnings. This means that in most cases, there's no legal obligation on the part of the police to read a DUI suspect their Miranda rights before questioning them as part of the DUI investigation. This doesn't mean that DUI and Miranda violations shouldn't be considered when evaluating a DUI case for potential defenses. At the law offices of Omar Zambrano, we go beyond the limits of your typical roadside DUI investigation and can take the necessary steps to exploit and legally challenge the officer's failure to provide a Miranda warning. So what's the good news? The good news is that you don't have to answer these questions. Seriously, you do not have to answer any questions regarding when, where, and how much you may have had to drink. Of course, the police won't tell you this because they're trying to arrest you for DUI. But the fact is, other than providing the police with your license and registration, you are not required to answer their DUI investigative questions, and there's no consequence for politely refusing to do so. The police may not like it, but that shouldn't be your concern. Hopefully this valuable tip will help you educate yourself about what actions to take to prevent a DUI. In the event you do get a DUI, contact the law offices of Omar Zambrano immediately for a free consultation. Contact Zambrano Law today at 1-800-562-0004